Today, we know the Supreme Court of the United States is 9 justices nominated by the President and approved by the Senate. But that's not what it always was. It had gone through several iterations, far different from what we have today. Even certain core tenets of the Supreme Court, such as who appointed them and what they actually would be able to review, were muddy before the August break. So please sit back and enjoy part 4 of the U.S. Constitution Explained, the Judiciary. And please, guys, remember, always hit that like and subscribe. Really appreciate it. Helps me out.
Get on a raft with Taft, boys, get on the winning boat. The man worthwhile with a friendly smile will get the honest vote. He'll save the country, sure, boys, from Bryanhurst and Kraft.
When the convention first started in June, it did not take long for the first discussions of a national judiciary branch to occur. So it was on June 4th that the judiciary branch was brought up for the first time, in which the framers were discussing the national executive, aka the president, having a veto. The original intention that they came up with was that the president could straight up suspend laws by himself. And while that idea would not make it out of June, James Wilson of Pennsylvania and James Madison of Virginia both thought that if the president and I quote, a convenient number of the national judiciary agreed a law needed to be suspended, then that law would be suspended. That idea did not come to a vote on June 4th, but Edmund Randolph of Virginia put to vote that a national judiciary be on the list of things they need to figure out, and every state voted in favor of that. Then the framers added the specific words of, quote, to consist of one supreme tribunal and of one or more inferior tribunals. The Supreme Tribunal would eventually become the Supreme Court of the United States as we know it, and after multiple iterations, the inferior tribunals would eventually become the federal district courts of today. This went ahead and passed, and on the very next day, June 5th, the framers wanted to substitute the Supreme Tribunal with the wording the Supreme Court. The 5th would also mark the first time that they discussed how they would be able to appoint the judiciary, whether it was an executive privilege or a legislative privilege. The only vote that would happen that day regarding that would be appointment by Congress, would end up being rejected by 8-2. That would not last very long, as these discussions were rather brief. They did, however, agree that judges should stay as long as they were in good behavior and would be paid servants of the state. They also voted to remove the idea of inferior tribunals and eliminated all reference to them, but would give the legislative the power to create such inferior tribunals if needed. This basically meant that the framers approved the idea of district courts, but felt that the future legislative would be better equipped to figure out how, when, and what their powers would eventually be. Shortly after this, the discussion on how the legislative was determined, the Great Compromise arguments, would overshadow all discussion in the Constitutional Convention, leaving the judiciary branch on the back burner until the 12th, in which they took a break from the legislative arguments for the Supreme Court herself. Here they discuss what jurisdiction the Supreme Court would actually have. They likely mentioned it on the 12th of June. However, it wouldn't be until June 13th that Mr. Randolph and Mr. Madison would actually open up the day with discussions on the national judiciary's jurisdiction. And I quote, "The jurisdiction of the national judiciary shall extend to cases which respect the collection of the national revenue, impeachments of any national officers, and questions which involve the national peace and harmony." In essence, this basically gave the Supreme Court had full and complete authority in cases that pertain to legal matter refraining from any form of national revenue, so tariffs and taxes, impeachment on federal officers, so any form of impeachment of congressmen, senators, presidents, any of that, they had case on it, or any cabinet members, etc. And in the broadest terms possible, laws that may have an impact on the harmony of the country. So that was basically any laws that would harm the nation's harmony, which in practice meant any laws that were between states or involved several states, kind of. This was agreed to, and then Charles Pinckney of South Carolina and Roger Sherman of Connecticut wanted to rediscuss the idea of the judiciary being appointed by Congress the same day, the 13th. After Mr. Madison argued against the idea of Congress appointing it, the two withdrew their motion. The whole committee then agreed that the Senate would be allowed to appoint Supreme Court justices. This would lead to the balancing of power between the two houses, in which the House would get the power of the purse, which you can check out in episode 2, and the Senate would have the ability to appoint the Supreme Court justices, who in turn could then deal with matters about dealing with taxes and tariffs. The convention would then immediately fall into chaos on how they would elect the Senate and the House, leaving the judiciary branch completely undiscussed until a month later on July 18th.
Get on a raft with Taft, boys, get on the winning boat. The man worth...
As stated, the judiciary branch was undiscussed while the convention went ahead and worked about discussing how to elect the House and the Senate and splitting up their powers. And it, once again, wouldn't be until July 18th that the topic would be brought up again. And July 18th, actually, several topics were brought up, but it was about midday that the judiciary itself became the main topic of the hour, according to notes we have. While most of the focus was being on who shall appoint the judges for the Supreme Court, the day was predominantly stalemate, with the motion for appointment by the executive failing 6-2, and an incredibly similar system to how it works today, with a nomination by the executive and confirmation by the Senate kind of working together, ended up failing 4-4. As I have mentioned before, with other topics that occurred, Georgia and New Jersey were not there for these particular votes, which may have changed the outcome of them. Framers such as Nathaniel Gorham believed that appointment by both of the legislative branches would be preferable, but he also thought that too many people would be involved to ensure a good choice. Thus, he was the one to propose the idea that the president appoints the judges with the advice and consent of the Senate, similar to that in which the Constitution of Massachusetts had. James Wilson approved of this and pushed it for a vote. However, several people, such as George Mason, would argue that the executive branch could not appoint the jury in the event of an impeachment of the executive, because, of course, the powers that the Supreme Court currently had was impeachment of all national officers, which meant, as far as the framers were dealing with on July 18th, impeachment would be handled by the Supreme Court in its entirety. He also would argue that a president who stayed in one state for years would grow personally attached to his state and would prevent out-of-staters from getting a deserved promotion. This, once again, harkens back to the idea that the Founding Fathers were very nervous about the idea that certain states would try and dominate the entire country, and had a fear of states being unequally represented. Because if you think about it, the United States being colonies, each one definitely had its own idea and was pretty separate from each other. The whole idea of a United States, it was there, but they weren't as connected as they are today. You know, for example, they often called the United States these United States, which implies plural, multiple states coming together, where during about the Civil War, we would eventually switch over to the United States, a singular entity. So, of course, they feared the idea that hypothetically, a president who stayed in Virginia for his whole life would get nothing but Virginians on the Supreme Court, in which case Virginia would basically be running the country. That's not exactly what they wanted. Any further arguments would cause stalemates, and all further votes on July 18th would be delayed until tomorrow. However, the couple of votes they did manage to take was they once again allowed the right for Congress to create inferior tribunals, was passed 9-0. This allowed the future creation and dismissal of the federal district courts, and the convention also agreed in a 9-0 vote that, quote, that the judiciary's jurisdiction shall extend to all cases arising under the national laws and to such other questions as may involve the national peace and harmony, which basically meant that federal courts were in charge of dealing with federal laws, and they would occasionally dip into state laws when it threatens national peace and harmony. This is different from what they agreed to on what they agreed to during June, because in June they only wanted them to deal with laws that affected national harmony, but now they were given a bit more broader power to deal with any and all federal laws. And while the original intent was that the judiciary discussion was picked back up on the 19th, it would actually be delayed a couple more days until the 21st of July, where the framers would eventually circle back to the judiciary branch, in which Mr. Wilson and Mr. Madison would attempt to argue for a council of revision. To simplify the whole discussion, what they wanted was a group of judges that before a law would be implemented would check if it's constitutional, and they would share veto power with the president to strike it down if it wasn't constitutional, which honestly would create a very interesting dynamic that no unconstitutional law would ever be implemented, because the Council of Revision would be able to strike it down before it's ever implemented. Nowadays, if a unconstitutional law is implemented, there's like 2 to 3 years where it can kind of play out while it's making its way up through the courts. That motion would fail 4-3-2, with New Jersey not voting and Pennsylvania and Georgia both divided. The last votes on the judiciary before the infamous August break would be back on appointment. In a defeated 6-3 vote, the idea of executive appointment once again failed, and finally, the last vote related to the judiciary before the August break was approving 6-3 selection by the Senate alone.
Get on a raft with Taft, boys, get on the winning boat. The man worth...
So let's go ahead and summarize, as this series has yet to cover anything really post-August break. That'll be the next set of episodes after these are kind of done. So in summary, before the August break, there was a lot of discussion on the judiciary branch and the Supreme Court. A original intent was that it was unnecessary, mostly because the president would have been able to just suspend laws. Eventually, and before the Great Compromise, the Founding Fathers and the Framers had already figured out that a Supreme Court was unnecessary and that the lower courts were also probably going to be needed, but they themselves didn't trust themselves to do the numbers yet. The lower courts would be determined by Congress at a later date, when they would be more in tune with what the nation needed. The first plans was for Congress to perhaps get the power to appoint the judges, but that would not make it very far. Eventually, before the August break, they had settled upon the Senate having the lone power to appoint judges, with the president having little to no say. The original intention behind this, as nowadays we see the Senate and the president balancing each other on the Supreme Court, the original intention was that the Senate and the House were the two being balanced, because the House would get the power of everything to do with national revenue. In exchange, the Senate would get the power to appoint the judges, who would be able to deal with the national revenue as well in terms of laws, because that was one of the explicit powers the Supreme Court would have. They had always intended on having lower courts, although it did disappear for a couple of weeks, which would be created by the legislative branch. And the powers of the Supreme Court had mildly changed over the course of June and July, but by the end of July, they had basically landed on a lot of what's physically written in the Constitution. Let's not forget that a lot of the powers of the modern-day Supreme Court would come from Madison versus Marbury in about 1800 or on 1800. I can't remember off the top of my head. Perhaps the most interesting of the changes of the convention was that Mr. Wilson and Mr. Madison's both attempted to argue for a council of revision right before the August break. It had almost passed, just barely failing, which meant there was clearly a lot of support for a mechanism that would ever prevent unconstitutional laws from taking place. But overall, it did fail, thankfully, hopefully for the better. And overall, the main arguments for the Supreme Court and the national judiciary was actually very underbaked before the August break, and would generally stay a tad underbaked. Like I said earlier, most of the power did come from Madison versus Marbury. But by the end of July, SCOTUS would be made up of an unknown amount of people, They would handle any issues related to federal laws and the nation's peace and harmony, along with anything related to the national revenue, and they were to be appointed and selected by the Senate alone. Key features such as the ability for judicial review, nomination by the president, and the fact that it would eventually settle on 9 would not be figured out until later. So thank you all for watching. Going to try and at least do a video a month. I would like to do more, but we'll see. You know, I have to read a lot of the arguments that were occurring and summarize it in a nice, easy format. For the future of this series, we're going to go ahead. I think there's like 1 or 2 more topics I want to cover in the pre-August thing. Then I want to discuss what happens during the final month after the August break, in which a lot of these ideas went under drastic changes to what we know today. So please stay tuned. Please hit the like button, smash it, as YouTubers say. Please subscribe, share this with some of your friends. I also want to state that I will be live streaming the Iowa caucuses. That'll be coming up. And really, guys, thank you for watching. Let's make 2024 a great year for this channel and a great year for you as well. Ciao.
Get on a raft with Taft, boys, get on the winning boat. The man worthwhile with a friendly smile will get the honest vote. He'll save the country, sure, boys, from Bryan, Hearst, and Graft.